So we'll continue to work closely with Germany. We'll continue to work closely with our other allies and partners in Europe to uphold Europe's own stated energy security goals.
So I think it's a bit disingenuous to claim credit for the 18 companies winding down. All of this work was done under the previous administration.
Matt,
you guys have only been in only been in office for a month, right? Are you telling me that in the last
Matt,
4 weeks, these 18 companies all of a sudden decided to say, "Oh my God, we better not do anything with Nord Stream 2"?
I am speaking for the
all of that. You guys are taking credit for stuff that the previous administration did. Right?
I am not.
No?
I am
Yes or no?
speaking for the Department of State.
Okay.
The people who have been working this, the people who are working this now, were the same people a month ago. Were the same people
3 months ago.
3 months ago. So
all right.
I want to talk to you about a subject that I've spent really much of my life studying, and that's the Supreme Court of the United States. The first book I wrote was called Men in Black. And in that book, you'll notice that the foreword was written by Rush Limbaugh. And that book came out in 2005. It was the #1 selling book on the Supreme Court other than The Brethren, which was a gossipy book about what clerks had been telling this particular reporter about the justices and so forth. That was not my book. I said at the time, when people rely on the court, they're relying on people who in many ways are highly political and highly partisan. There are 3 justices today who comported themselves with great honor, who have respect for the rule of law and respect for you. Just 3 out of the 9. In those 3, the great Clarence Thomas, thank God for Clarence Thomas, the great Sam Alito, who has been absolutely exceptional, and Neil Gorsuch, who's either really, really good or not, but not Kavanaugh and not Coney. Now, what am I talking about here? This is how Reuters puts it. U.S. Supreme Court formally pulls the plug on election-related cases. The U.S. Supreme Court on Monday brought a formal end to 8 lingering disputes pursued by former President Donald Trump and his allies related to the election. The justices turned away appeals by the Republican Party of Pennsylvania and Republican members of the state legislature of a ruling by Pennsylvania's top court ordering officials to count mail-in ballots that were postmarked by Election Day and received up to 3 days later. They did more than that. They eliminated the signature requirement and other requirements. 3 of the 9 members on the court, 6 conservative justices, well, that is a lie, and they'll continue to do that in the media because it serves their narrative. Clarence Thomas, Samuel Alito, and Neil Gorsuch dissented from the decision not to hear the Pennsylvania case. The High Court, as expected, also rejected 2 Trump appeals challenging Biden's victories in Pennsylvania and Wisconsin, based on claims that the rules for mail-in ballots in the 2 election battleground states were invalid. The court also turned away separate cases brought by Trump allies in Pennsylvania, Michigan, Georgia, Arizona, all states won by Biden. And then they say Trump made false claims and so forth. Well, how do they know Trump made false claims? The court won't hear it. This court won't hear him either. Why do the media report this way? Anyway, on the Pennsylvania case, I happen to be familiar with both of them. The one to me that was the strongest of the cases was the one that was a straight-up challenge under Article 2, Section 1, Clause 2 of the Constitution, which is very simple. That is, that the Supreme Court of Pennsylvania, the Attorney General of Pennsylvania, and the Secretary of State of Pennsylvania have absolutely no authority to substantively change election laws in the state. Yet that's precisely what they did. Now, that's not the way it's explained by Reuters or AP or any other news organizations, but that's exactly what they did. Now, you have 3 justices who wanted to hear that case, 6 who did not. So what happens next cycle, which is exactly the point of the dissent? We're going to be right back here again because this wasn't resolved. And I can guarantee you that the leader of this sort of rogue effort is the Chief Justice of the United States, John Roberts. But the fact that Coney and Kavanaugh joined with Roberts and the leftists on the court is appalling. What is the use of the Supreme Court? It gets involved in every damn thing imaginable. Every cultural issue has to be run by the Supreme Court, whether it's abortion or prayer, whether it's nativity scenes, whether it's marriage. Every single cultural issue is run by the Supreme Court. Why? All they are lawyers. Why do they control what happens in every state, in every town, and in every public square? But here we have something that occurred under the federal Constitution, where the framers could not have been clear. The state legislators, even John Roberts should be able to read that. But 6 of them, including Kavanaugh and Coney, the great Kavanaugh and the great Coney, decided not to get involved. Shame on them. They have helped to pour fuel on the fire of the division in this country by failing to uphold the United States Constitution and drawing a line. That's their damn job, not to interfere in all these other matters. Now, the second Pennsylvania case, which is straightforward, black and white, simple as can be, the Pennsylvania state legislature, Republican, and the Democrat governor conspired to violate their own constitution. Now, you might say, what's it have to do with the federal government? Nothing, except it involves the selection of electors who choose the president and vice president of the United States. So it has everything to do with the federal Constitution. It's not a federalism issue. In other words, state legislatures are free to conduct themselves as they wish within the civil rights requirements and so forth. But they're not free to violate their own Constitution in order to create a situation where you have tainted electors being counted in Washington, D.C. on the day those electors are counted. So they disenfranchised the people in Pennsylvania by not actually amending the Constitution, by effectively passing a statute in lieu of an amendment that allowed for mail-in voting. And they felt pressure to do it because of the pandemic. We're destroying our country based on this pandemic. You understand, the left is running right through it. That was a simple up and down case. And the state Supreme Court of Pennsylvania, with a variety of outrageous tricks, wouldn't even hear it. The appellate court in Pennsylvania, this appellate judge, she was fantastic and courageous. She said, yes, I'm going to hear this case because the plaintiffs in this case make a very serious argument that our state constitution was violated and that it taints and has an effect on the federal constitutional process. She was shut down in 72 hours by a partisan elected state Supreme Court. Shut down. And then they shut down the petitioners. They made it impossible for the petitioners to even have their day in the state Supreme Court, and now they don't get their day in the federal Supreme Court. So there's your court system, ladies and gentlemen. What a crock. What a joke. Good job, John Roberts. Those were the 2 most important cases because they specifically addressed the federal constitutional system, which was violated in Pennsylvania, which was violated in Wisconsin, which was violated in Georgia, which was violated in Michigan, and frankly, was violated in Arizona. And so now what? And so now guess what, ladies and gentlemen? The Democrats are going to feel that they can do whatever the hell they want in these states. And they're going to go back into these states, and they're going to push an agenda even further to make it absolutely impossible to win the states. In other words, your United States Supreme Court rewrote the federal Constitution of the United States by not acting because it allowed these rogue actors, all Democrats, except in the one instance in Pennsylvania with the Republican legislature, allowed them to change the language effectively, practically, in terms of implementation under the federal Constitution. Your federal Constitution was changed in the last election. I don't give a damn what the New York Times, the Washington Post, Dominion this, that. I don't care what any of them say. I'm not even addressing fraud. I'm addressing a crooked system, systematic violations of our constitutional system. And there they are, 6 of the 9 justices, sitting on their asses, doing not a damn thing about it because they're afraid of what will be said about them in the editorial pages of the New York Times and the Washington Post. Cowards, absolute cowards. There's your Justice Coney. There's your Justice Kavanaugh. You fought like hell for them, and then they spit on you. But the justices did have the votes. Well, I should say the opposite. The justices took another pass today. They think it's okay for a local Democrat prosecutor to get the tax returns of a Republican president, whether he's in office or out of office. Now, what kind of door does that open? What kind of an idiot do you have to be to not understand the precedent that that creates? Any pretext for investigating a president now by some slob out of some city or town or county, any pretext that they can pull together to make it seem like a legitimate investigation will now be a basis for a president having to provide his tax returns. Just because Democrats and the media demand the tax returns of somebody, I open the Constitution. It's not in there. There's no requirement. As a matter of fact, let me suggest this to you. You know, when the Constitution was originally written and adopted, there was no damn income tax. There was no Internal Revenue Service. So now some jerk elected district attorney in Manhattan, Vance Jr., whose dad was an idiot too, a clown, a Secretary of State who resigned, under Carter of all people. Now he says, now we shall continue on. Continue on. They tried the Emoluments Clause. They've tried everything they can against Trump. But now here's what I believe. I believe all the financial records of every Supreme Court justice should be revealed. That we need to have transparency. That branch of government is cloistered and hidden behind very thick marble walls, which, by the way, has chiseled above the door Jesus and Moses, the Ten Commandments, all the things we're not allowed to have. That's what they walk under every day in order to get to their office. No hypocrisy there. So we need transparency. We need to know all about their financial relationships, family members, because after all, they have the final word, quote unquote, on the Constitution. Just ask them, they'll tell you that. And we need Nancy Pelosi's tax records and her dumb husband. Why just Donald Trump? Why just Donald Trump? I'll be right back.
Mark Levin.